Well, most Supreme Court justices did not graduate from law school. Of the 114 Supreme Court justices in our nation's history, 49, only 49 actually graduated from law school. The first Chief Justice, John Marshall, attended the very first law school in the country at William and Mary, but did not graduate. Harvard Law School was not invented until 28 years after the United States Supreme Court opened for business. Lawyers became lawyers the same way blacksmiths became blacksmiths. Training. You trained as an assistant to a blacksmith, and eventually you could go into business as a blacksmith yourself. Abraham Lincoln, who never even went to elementary school, was entirely self-educated. He read law books, got some training in a law office in Illinois, and eventually became a very good lawyer. The last Supreme Court justice who didn't go to law school was Jimmy Burns, who went from being a South Carolina senator to the Supreme Court in 1941. He was, of course, confirmed unanimously without even having a Judiciary Committee confirmation hearing, as was the custom in those days. In fact, Jimmy Burns was confirmed by the Senate on the same day that the Senate received his nomination from the president. He was the last of the no law school Supreme Court justices. Since then, Harvard Law School graduates and Yale Law School graduates have come to dominate the Supreme Court and the rest of the federal judiciary. Now, federal judges are supposed to arrive in their jobs with enough education to actually do their jobs. But in the 21st century, Republican billionaires have decided law school isn't enough. And so they have been hosting federal judges on very expensive vacation trips to luxury resorts, including a luxury ski resort in Deer Valley, Utah, where some of the judges' time is spent on the receiving end of lectures about something called Corpus linguistics. Molly Redden reports it all in a new article in Huffington Post under the headline, Inside the Ritzy Retreats Hosting Right-Wing Judges. She reports that Corpus linguistics, quote, essentially works like a search engine that returns every example of how a word or phrase was used in a select database of historical texts. But the leading proponents of legal corpus linguistics see it as something more, a powerful new tool to shore up the legitimacy of the conservative legal movement. Now, judges claiming to be interpreting the Constitution as it was originally understood could wield the imprimatur of big data. With a 6-3 stranglehold on the Supreme Court and Trump judges dominating federal appeals courts, the right wing has increasingly pushed the legal view that the law must be interpreted based on history and tradition. Yet few have failed to notice how perfectly history in these judges' rendering aligns with current Republican beliefs on issues like guns and abortion. Corpus linguistics offers one way to dodge these criticisms. A judge who could keyword search millions of lines of historical text, the thinking goes, is a judge who could ward off accusations that his version of history was invented for a partisan outcome. The report describes the workings of a nonprofit that calls itself the Judicial Education Institute. The first retreat they hosted for judges was, quote, 6 days at the Greenbrier, an opulent 11,000-acre West Virginia mountain resort. At least 11 U.S. district and appeals court judges listened to speakers vaunt the potential of corpus linguistics in the mornings. In their free time, they could indulge in one of the Greenbrier's 4 golf courses or miles of trails. Deer Valley, the same ritzy resort where Gwyneth Paltrow skied into legal trouble, provided an even more exclusive backdrop. At least 7 federal judges attended. 1 U.S. district judge, Stephen McGlynn, reported his trip alone cost the Judicial Education Institute $5,558. Now, How do we know how much Judge McGlynn's free trip was worth? It was a mistake. Judge McGlynn disclosed that number by mistake, not realizing that he was not required to disclose how much the trip was worth. And so we don't really know how much the judges are actually taking in the form of vacation luxury. So of the work of the Republican judges using corpus linguistics, some of it has found its way into Supreme Court Justice Clarence Thomas's opinions. University of Connecticut Law School professor Anya Bernstein says, a lot of what legal corpus work tends to do is allow you to pick and choose your history. You pick and choose your corpus. You pick and choose what you're putting into the software. You pick and choose your results. Today, Senator Sheldon Whitehouse said this.
They've opened up a whole new arena for fake fact-finding with the new so-called history and tradition analysis that they brought to bear on Dobbs on reproductive rights cases and in Bruen on gun rights cases. Because you can fake your way through history and tradition very easily. You just go back into history and you cherry pick the fake facts that you like. Real historians will come in and say, well, that was ridiculous, but it doesn't matter. You got what you wanted. And the ability to do that fake fact-finding is going to get worse, not better.
Leading off our discussion tonight is Democratic Senator Sheldon Whitehouse of Rhode Island. He's a member of the Senate Judiciary Committee, and he chairs the subcommittee on federal courts. He is also the author of Captured, the Corporate Infiltration of American Democracy. Senator, thank you very much for joining us tonight. You know, I read these articles that are all new to me, always thinking, how is Senator Whitehouse reading this? And I'm sure it's not with any element of surprise.
Nope, no surprise at all. If you look at the billionaire-funded effort to influence our judiciary, they've been picking judges and justices. They've been creating doctrines for them in billionaire-funded doctrine factories. They've been presenting them to the judges and justices through billionaire-funded front groups that file amicus curiae briefs in cases that are brought by billionaire-funded litigation groups. And as indicated here with the Greenbrier and Deer Valley, they're also indoctrinating the judges in the doctrines that they're trying to get them to adopt by taking them to fancy resorts so that they can learn what they're supposed to do. And unfortunately, this is not new behavior. For a long, long time, very wealthy special interests have been taking judges to fancy resorts to learn doctrines that will help those special interests win cases in the courtroom.
Yeah, and when we talk about the data searches that they're doing, the corpus that you choose, which is to say the category of data you want to search, can be designed to produce a certain result. I mean, if people watching this now were imagining us 100 years from now, doing such a search and asking for Republican senators' views of X, you will get a bunch of quotes that would fit a certain way of thinking, but would leave out everything that Democratic senators were saying about exactly the same thing at exactly the same time.
Yeah, as they say in computer business, garbage in, garbage out. Only in this case, it's not just garbage in, it's specifically chosen garbage in order to produce the desired garbage out. And then because of the Supreme Court doing this reversion to a history and tradition form of analysis, something that was not the regular form of analysis until Bruen and Dobbs, it's opened up this whole field for cherry picking of the historic record for the judges on the Supreme Court to create. And weirdly, the hearing, the resort trip that was discussed happened in, I want to say, October of 2022. Mm-hmm. These two decisions, Bruen and Dobbs, that developed the new history and tradition analysis, they were only decided in June of 2022. So it's incredible how fast these billionaire-funded groups were able to get their indoctrination training out to take advantage of this brand new history and tradition standard. That's like 4 months. You can't even organize a parade in 4 months. And these people had this all teed up to fit into the history and tradition analysis 4 months after those were adopted by the court.
And before I knew, certainly, the techniques they were using in their so-called historical research, we had historians on this program from Harvard, from Yale, from Stanford, finding great fault with the amateur history work done by Supreme Court justices.
Yeah, I mean, I'm a trained lawyer, and I've been doing trial work and litigation and legal analysis for a long, long time. That's what I'm trained for. And that's what Supreme Court justices are trained for. They are not trained historians. And particularly if they come at it with a bias, because the same billionaires who got them put on the court want them to adopt particular.
I don't have any sound here. I'm not sure if can you, control room, tell me, am I the only one who doesn't have sound? I don't have any. Okay, we're back to Senator Whitehouse. Okay,
I'm back.
Okay, go ahead.
No, I was just going to say the notion that this is an accident is completely mistaken. It's not just bad history; it's deliberately contorting history to get to results that the same donors who got you on the court want you to arrive at and have told you how to get at through all the amicus briefs that they file in these little flotillas of front group briefs. It is a systematized indoctrination of a court that has been captured.
What is at stake in the presidential election when you look at the potential judicial nominees of a second-term President Biden or another Trump term?
It's pretty stark. The Trump appointments have been really dramatic in terms of taking away rights from people. And if with a 6-3 majority, it's a pretty powerful majority. But if you got to, 7-2, it gets even wilder. And it also builds in over a longer period of time the ability of big billionaire donors to manipulate and maintain and cosset a Supreme Court that will do things to the American public that even conservative Republicans would never do in Congress because they'd get voted out. So it's a really, really dangerous end run around the American democratic political system that gets only more dangerous and dynamic as the majority grows.
Senator Sheldon Whitehouse, thank you very much for joining us once again tonight.
Thanks, and sorry about the mute.
Thank you.